some examples of digital assets. Now, there's a couple here that I want to dive deeper into. Just listing them, we have electronic documents, social media accounts, financial assets and financial information, business accounts, blogs, podcasts, pictures, stored videos. Let's first start with electronic documents. Just as we had mentioned before, you have statements. Well, now there's files that are stored electronically that are going to be on your computer, maybe on your phone. How do you incorporate electronic documents that are specific to you if you want that to be available and accessible to your loved ones, or if you want to transition that to your loved ones?
So the lawyer answer to that is it depends, right? It all depends upon what medium you're using for storing your digital documents, right? So the answer is, if you have something in Apple iCloud, then it's a totally different process than if you have something in Google Drive, right? So accessing this when somebody dies is going to be dependent upon what rules each custodian has in place. And if there's something called an online tool where you can designate a recipient of these digital assets. And if there is no online tool, then you would look to the will. And if there is no will, or it's silent in the will, you then look to the terms of service agreement for the individual custodian of the asset. So it is the Wild West out there, and there's no uniformity as to what you should do for every single digital asset.
So it's kind of a case-by-case basis of doing some research on what's available for that particular product or that particular use.
It is. And in fact, Apple just created their legacy tool, or their digital legacy contact, where you can designate an individual to access certain parts of your Apple account, right? So they can access your iCloud account, they can access your email account, but they can't access, say, your music or your books or your movies. Whereas Google has an inactive account manager feature, where if your account is inactive for a certain period of time, which you can designate, say 3 months, at that point, the designated recipient can then get access to the items on your Google Drive, your Gmail, right? All of those things. So it really depends upon what each service provides. And then there are tons of services that don't have any online tools, and it's completely silent as to designating somebody to receive access to those digital assets.
Wow. You mentioned something I actually want to back up and hit on. If you don't have a will, some individuals listening, watching this, those that might watch the replay, are sitting there without a will. It's unfortunately not uncommon. Even for some of our clients, we really need to press and push and hold them accountable to getting a will established. What if there's no will and both spouses pass away? What happens then? How is it determined where assets go? Physical assets, but then maybe even digital assets. If you could touch on that, because I think there's people sitting in that seat right now.
So fortunately, every state has a law called the intestate law that provides that if somebody doesn't have a will, then the state will decide how everything goes. And it in general terms, it will go to a spouse or children or grandchildren or parents if people are deceased. You have to look at every intestate statute separately to see what the specific requirements are and what each state says. But if you don't have a will, then the state will determine how things flow down in your estate.
Fair to say that it's sorry to jump in. Is it fair to say that's either it's a longer process or maybe a more costly process if there's no will to settle in a state?
Yeah, so it can be a more costly process because the person who is appointed as what's called the administrator when there is no will has to be bonded. So they're going to have to put up a surety bond in order to be appointed to the administrator. And there's a cost to that, right? There's cost, there's time. And so things are not always passing the way you want them to pass and in the most efficient manner if you don't have a will.
Right. No, I wanted to make sure we hit on that. Let's kick it back to the slide here. social media accounts, Facebook. What happens to your Facebook account when you pass away if no planning has been done? And then what are you advising your clients for accounts such as Instagram, Facebook, etc.?
Yeah, so Facebook has a legacy tool where you can designate somebody to put up a legacy page for you. In the absence of you doing anything affirmatively, then we look to what the will says. And in the absence of anything in the will, it's going to be the terms of service agreement. So with the terms of service agreement, it's quite possible that your digital profile could be deleted.
Along with
And
all photos that might be stored or posted there as well?
yeah, so
Wow.
let's take Apple for a second. The terms of service agreement for Apple says that you have a license to access music and videos and books that you purchased during your lifetime, and those are non-transferable. And it also says that all the items on your iCloud account are deleted at your death. So if you don't designate somebody as the legacy contact to access this information, and if you haven't put anything in your will that would otherwise give the executor the authority to access some of this information, then it's quite possible that all of this stuff could be deleted. Now, this is especially problematic if you use your iCloud account and store important things on your iCloud account, right? So
Right. Yeah.
if you are a writer and you have your manuscript stored on your iCloud account, or if you are a researcher and you have your research stored in your iCloud account, or if you own cryptocurrency and your private keys are stored in your iCloud account, it is quite possible that those things could be deleted if you haven't planned properly.
Wow. And I know a lot of people, family members of mine, utilize Facebook as the best photos, right? You take a bunch of photos, but you put the best photos on Facebook, and many times, those are the ones that you likely want to hold on to. That's an interesting point. I mean, I'd love to know what percentage of Facebook users have gone ahead and actually made that designation.
I would say probably a small number of people are actually using the services provided by Apple and Google and
Mhm.
Facebook.
Yeah. I mean, that's why we're doing this. That's why we're having this discussion. It's common sense, but who's executing on it? And I don't think we're thinking about it. So I think it's why this is very relevant. So we connected on Bitcoin and cryptocurrencies. What about PayPal? I'm a PayPal and Venmo user. What happens to the assets that are in those respective accounts?
Yeah, so it falls into your estate, and the executor would be able to access it under the terms of the will if the executor was given the authority to access. But
Hmm.
those are perfect examples of digital assets that we typically don't think of. We typically think of, well, most people think of cryptocurrency as digital assets, right? If
Right.
you say to people, do you own any digital assets? They'll say, well, I don't own any crypto, so no. But the answer is yes. If you use Venmo or PayPal or Apple Pay, or if you have photos on your phone or music or any of those things, those are all things that you need to account for with the executor so the executor can gain access. And part of the process is reaching out to these companies after the
Sure.
person has died, making sure the executor is the one reaching out to these companies and you're doing it the right way. The last thing you want to do is impersonate the decedent, use the decedent's username and password, and just log in. Because once you do that, these companies will lock down the account and may force you to go to court in order to gain access to the assets.
And they theoretically know because of the decedent's public information and date of death, they can track when there was another login. Is that correct?
Yeah, so what Google does is if there's a designated well, regardless, the executor is going to have to provide proof of death, a death certificate, proof of
Hmm.
appointment, a short certificate, and Google will then say, okay, the person died on September 20th. And
Hmm.
if there was access between September 20th and the day that the executor put forth the request, they will know that there was unauthorized access
Right.
and they'll shut down the account.
Wow. Wow. So that's when it's done correctly and they can then create their own username and password, I would think, to access the deceased, assets. Is that how that typically works?
So what happens is the executor puts forth that request, and then
Hmm.
Google will send that information to the executor. You
Okay.
don't create your own separate account. You don't log into the decedent's account. The right way to do it is to get the information directly from Google or Facebook or Apple or whoever. The problem is it is a violation of both federal and state law to access a decedent's account and use their passwords and impersonate them.
Sure.
So
Yeah.
your executor is potentially subjecting themselves to criminal liability. And if you're an advisor, you're advising your client to do this, to access it,
Yeah.
is participating in criminal liability.
Yeah. That's probably not thoroughly thought through, and probably occurs just with the executor not knowing, what else. And if they have access to that information, like a pad of paper with usernames and passwords on it, like my father keeps, then if it's there, it's probably utilized without knowing the channels or the proper channels and proper laws to go through. Yeah, this
And
is.
people say to me all the time, like if you have a deceased spouse, they'll say, well, who's going to care, right? Like, is the Department of Justice really going to prosecute a deceased spouse, a widow, because they're accessing their spouse's email account? And the answer to that is probably not. But A, it's illegal and you can't advise somebody to do something illegal. And B, it becomes more complicated if your designated recipient is different than the person who's the beneficiary under a will, right?
Oh, okay. Yeah.
Once you start having different people with different access and different rights, that's when this becomes problematic. So the best advice is do it the right way, contact the company, contact the custodian, and go through the proper channels.
Wow. That's that's great. What about business accounts or the rest of this slide? Anything that's relevant to point out? I know I had one question, which was, what if there are digital assets in the business? How is that accounted for in terms of a transition, or how should that be handled at death of the business owner, or at least someone heavily involved in the business? Naturally, if there's personal digital assets, there's the potential and likelihood that there are business digital assets as well. That was my kind of only question on the final three here.
So with business owners, it's not uncommon for there to be a mixing of business and personal with business accounts, right?
Hmm.
So the first thing you want to do is that if you are creating business accounts, they should be in the name of the business, right? So don't put an email account when you're setting up these business digital assets, email accounts, website domains, blogs,
Hmm.
all of those things. Make sure that they're owned within the business and not in the business owner's individual name. Because if they're owned in the business owner's individual name, it flows through to the estate, and that can disrupt the flow of business,
Hmm.
right? If, however, they're owned within the business, then the business can continue on after the owner dies through the executor, right? There's still
Yeah.
mechanisms in place for the business to continue. Another thing you want to make sure that you're doing is you want to make sure that there's somebody in the business who is aware of what these business assets are, where they're
Hmm.
located, how to access them, to make sure that access can continue post death of the business owner. Because if I own an email account in my own individual name, nobody can access that except for potentially my executor.
Sure.
But if I own a business that owns an email account, then people within the business can
Makes sense.
continue to access that after my death, right? So we
Got it.
want to make sure that we're setting up our assets in the proper way so that
Hmm.
there can be continuity and no disruption of business flow after the death of the business owner.
Thank you for watching our video. Please remember to subscribe to our YouTube channel. Look at our links below for ways of getting in contact us, and message us if you'd like us to add you to our monthly newsletter.